Welcome to the SCOTUS blog debrief of the oral argument in U.S. Patent and Trademark Office versus Booking.com. My name is Tejinder Singh, an attorney at Goldstein and Russell. I'm joined today by John Duffy, who's a professor of intellectual property at the University of Virginia and an avid court observer himself, having clerked there for Justice Scalia. We did a preview of what was going to happen in this oral argument last week. We had a chance to listen in yesterday, and now we're going to provide some thoughts. There are two big topics that we really want to get into today. The first one is just what does this new world of oral argument look like, where it's happening over the phone and all the justices are asking questions that way. And then the second is going to be more about the substance of the case. But I want to kick it over first to John. What did you see? What did you think about the new form of oral argument?
Thank you, Tejinder. I thought the new form of oral argument went quite well. I was surprised at how well it went. There were a few glitches here and there, but surprisingly few. There was, I think, in my notes, there was a little bit of dead time between when the Chief Justice went from Justice Alito to Justice Sotomayor. There was a little bit of silence there that went on a little longer than you would have thought, but it was still an order of seconds or something like that. Not very long at all. The other thing that other adjustment I think that had to be made is that the Chief Justice had to cut off the advocates pretty much after every series of questions and cut them off kind of mid-sentence. I mean, he did the best he could, but there's no body language that was possible for him to be sort of telling them, okay, we're going to move on to the next person. So he had to sort of jump in. And sometimes it was a little bit abrupt, but he needed to keep the argument moving along. And I think he did that quite well. The questions, obviously, all the justices, including Justice Thomas, asked questions. Justice Thomas is the most senior justice after the Chief Justice. So he got to ask the first questions after the Chief Justice questions. So the first among the associate justices. And he didn't let us down. He asked very good questions. He started off the questioning of the government's attorney by asking about 1-800 numbers, which is something I'm sure we're going to talk about in just a few minutes when we get to the substance of this. I thought that was, sort of a good question that goes to the heart of the government's case about whether just sort of taking a sort of standardized component and adding it to a generic term is always untrademarkable. The government has allowed those trademarks to exist. So I thought that was very good. And the other thing that was interesting to me is that even though there was no crosstalk between the justices sort of fighting back and forth, as they sometimes do at oral argument, that you'll see a justice on one side of the bench ask a question and another side of the bench literally across the room seems to be not so much asking another question, but answering that first justice's question. Instead, this was a sort of serial progression. And the argument worked quite well in that. So very often, multiple times, the next justice in line would say, well, I have a follow-up question to your response to Justice Sotomayor, or Justice Kagan, or Justice Ginsburg. They sort of looked back to the questions that were just being asked. And I thought that worked out much better than I would have thought it would. So the questioning didn't seem to be just isolated questions from the 9 justices. There did seem to be a sort of flow to the argument, much more than I think people would have expected. So overall, pretty high marks on the format.
Yeah, I agree. I thought one of the most interesting things was that everybody asked questions, because normally, for those of us who try and predict Supreme Court cases by watching oral argument, one of the things we rely on is who's not asking questions of any given party, right? If you're not getting hostile questions from Justice Alito, there's a pretty good chance Justice Alito is going to vote for you. Similarly, if Justice Kagan is not asking you questions, you're probably okay with her. But because everybody asked questions to each side, the prediction game was a little bit harder. We were missing that input. And also, I do agree with you that the tone of the questioning was less, it seemed less like the justices were actually talking to each other, which is often what they say oral argument is really all about, and a lot more like they were having individual one-on-one conversations with the advocate, obviously building off of what had come before, but I think trying not to be repetitive while still allowing the conversation to get deeper on the topics that they perceive to be at the core of the case. So I thought that was all kind of super interesting. In a lot of ways, it was a kinder, gentler version of oral argument from what we get in the normal Supreme Court day, and in that way, a little bit refreshing. I thought it was also, good how the Chief Justice was able to give everybody a chance to ask questions. I had a big question when we were getting up to like the 30-minute mark of the first presentation about whether the junior justices were just going to have to be quiet for this whole next 2 weeks. And it looks like they've found a way around that, which is to go over time. But even that is, I think, kind of a remarkable change to how the Supreme Court normally does business, because usually they're pretty persnickety about the time limits, and they seem to kind of go out the window. Not only, for example, when Ms. Ross was up for the government, not only did each justice ask questions, but then she was given a minute to sum up, and then she got to do a rebuttal later. So they were pretty loose with the time, which is cool, I think. I really like how in other courts, you can often get a little bit of flexibility about time if there's more conversation to have, but the Supreme Court tends to be really strict. So it's nice that they've relaxed that to kind of allow the conversation to flow a little better. I do think, though, that what they're probably trying to do is keep each justice on about a 3-minute individual clock. And so now that advocates know that, I wonder if going forward, you'll see them treating each of those questioning periods as sort of discrete 3-minute intervals. I wouldn't be surprised to see people with stopwatches at their desks, just making sure that they can get 3 minutes of content discreetly out for each justice as they go forward.
I did think one thing about that is when we say they allowed, some flexibility in time, it was, I think, 10 or 15 minutes in addition to the time that they had allotted. It wasn't a huge amount of additional time at the end of the day. I mean, given all the adjustments that our society has had to make over the last few weeks, it's not like they had a 3-hour argument. Or something else like that. And of course, historically, if you go back to the 19th century, oral argument often stretched over days in famous cases. So we're not going to go there. I think we're going to get a few extra minutes. And as you said, the advocates might begin to make adjustments themselves to try to keep that to keep their own time limits so that the argument remains about an hour.
Yeah, I just want to remind all the people who are watching this live that you can submit questions and we will try to answer them. We've got a couple that I wanted to field because they're about this topic. So the first one was, the public only gets audio. Can the justices see video streams of each other? I believe the answer is that everyone is audio only. I'm not aware of any private video conference system being set up. That said, it would be kind of awesome if like Justices Breyer and Thomas were on FaceTime in parallel so that they could resume their normal kibitzing that they do on the bench. If you've been to a live Supreme Court argument, you'll see the justices frequently passing notes and whispering side conversations, and I think it would be hilarious if that was happening, but I'm not aware that it did. I don't think it did.
Or if they had a side chat mechanism like we have here, we have on Zoom, we have a side chat mechanism. And of course, they would be, I think, very worried about that. One nice thing about paper is that the paper notes get destroyed. If you type it into Zoom, it's probably there forever, or the justices would at least be wise to assume it would be there forever.
Yeah, and then the second question we have is, do we think the new format affected the advocate's approach and tone at all? I would venture to say maybe it was so new to everybody that I'm not sure they could have had like a whole new strategy. I'm sure they would have prepared just with telephonic arguments, getting used to not having the visual cues that you often rely on at argument to see how you're doing. I do think that there was a moment at the argument yesterday where Lisa Blatt was kind of commenting on a concern, and she said, okay, I think I've heard 6 of you now express the same concern, so let me try and really focus in on this. And I think that that's an advantage conferred by the fact that everybody is asking questions. You can get much more of a poll of what's going on the whole court than you could in an argument where only 2 or 3 justices are asking questions. Other than that, though, I think that both advocates actually did a really good job, and they sounded kind of like themselves. And so I don't know that there were huge changes, but it would be an interesting topic to get them on the phone sometime and ask them that question directly.
It would seem interesting to think that sometimes you can tell whether an argument's working by just its effect on the justices. Justices, just like any other human, justices will nod or look quizzical or do some other body language that gives you a sense of whether the argument is gaining some purchase with the court or not. And I think that was missing. And it, Lisa Blatt did a very good job of trying to sort of do an on the fly poll based on the questions that the justices were asking. But I wonder if some of the arguments that each advocate was making were things that the justices weren't buying, and they just couldn't tell that the justices weren't buying it because they missed the visual clues.
They concealed the face palming.
Yeah. Or the rocking back in the chair, where the justices have these chairs that go way back. And one sure sign that you're not scoring points is when the justice sort of looks back and leans all the way back in a chair and sort of thinks, no, that's not going to win me over.
Yeah. We have a third question here, which is, do we think that this structure is going to make its way into in-person arguments later? I say it's too early to tell. We've had one of these, now two, if you count this, also this morning. And so whether we think it went well, but whether the court agrees that it went well is really the only question that matters. And so we'll know more after 2 weeks about how many of the innovations from this stage of arguments they want to keep into next term. And also, there's also a question about when we will resume in-person arguments. I think everyone is hoping that in October we'll be back to normal, but this may endure for a bit longer. Nobody really knows for sure. And so I think it's early to tell what's going to happen after this is all over. But I would hope, that when we see innovation and we see innovation working, that the court would be happy to pick it up. And there are lots of areas where the court has embraced some changes. I think their website has gotten like orders of magnitude better over the last year or two. Of course, that's all stuff happening outside the courtroom. They've been notably reticent to do things like live streaming, but I think the fact they're open to it, even in this unusual circumstance, signals that, there is some wiggle room, some room for them to get more updated in how they run things like oral argument. But, let's wait and see. I think, though, this would be a great time to transition maybe into the substance of the case. And what we saw there. John, do you want to start the discussion with what you thought were the most interesting things from an IP perspective?
Well, I thought like many intellectual property cases, there's two themes. There's the intellectual property theme, which I think came out in questions of the sort of value of intellectual property. And then at least some justices have this fear of monopolization, which is a very, very standard policy issue in intellectual property. It's probably most pointedly presented in the patent field, where I teach and write a lot. But in each field, this is a concern for some of the justices about, is granting intellectual property rights going to lead to too much market power? So that was one major theme that we heard a lot about. And the second major theme, which I think is interesting more on a jurisprudential level, is the relationship between the statutes and the common law, which started off the questioning. Chief Justice Roberts opened the oral argument and had the first set of questions, and then it went to Justice Thomas. And he started off the questioning with whether the court should really be sort of looking first to this 19th century case, this 1888 case on Goodyear, on two companies named Goodyear, and whether Goodyear rubber, which was at that time a generic term for a particular type of rubber, whether that could become proprietary or trademark just by having it the Goodyear Rubber Company. And the Chief Justice said, well, should that be our poll star? And we should take that as like the touchstone and then reason just from that? Or should we start with the statutory language that Congress wrote in the Lanham Act, which is the Federal Trademark Act, start with that and reason from that, and not be too concerned about how consistent or inconsistent our reasoning is with Goodyear. I think that's a major issue in this case from a jurisprudential standpoint. And it seemed to me like Goodyear was losing that battle at the oral argument. Now, that's also, I must admit, that's my bias, that the court should probably start with the statute and not with case law. And I don't think the case law is irreconcilable with the statute, but given that there is a statutory language here, which everybody seems to think is relevant, it seems like a modern court should, and I think will, start with the statute. And then Goodyear is consistent with the statute, but in terms of where you start and how you proceed in your reasoning, I think the statute seemed to be winning that battle. There were times where the justices said, well, put aside Goodyear and let's just talk about what happens if we don't follow the Goodyear exactly the way you, the government, think should be followed. So I thought that was a major point, and Goodyear seemed to be losing that battle. On the intellectual property issue, the fear of monopolization, I think, was something that concerned the justices. And that's, in fact, the point that you just made, where Lisa Blatt said, well, I can hear questions from the court that many of you are concerned about this. And then she began to talk about all the doctrines in trademark law that prevent people, not just in .com trademarks, but in all kinds of trademarks, from locking up too much intellectual property or gaining too much market power through their intellectual property, gaining an unfair amount of market power due to federal trademark regulation. So that's where I saw the argument going.
Yeah, for me, the Goodyear thing is interesting because I think it's bound up a little bit in a broader debate that the court is having internally about when it's going to start overruling or cabining its own precedents. I think there's a lot of anxiety from what most people describe as the more liberal members of the court, that a lot of precedents are going to start getting overruled by this sort of new conservative majority. And so I think there's a bit of a tug of war going on there about just when is the court going to adhere to precedent, when is it going to distinguish precedent, and when is it going to overrule it. And those are sort of all points on a continuum. And with respect to Goodyear here, it's an interesting case because it's so old and so obviously not directly controlling of the questions here. And so I think there are opportunities to do a lot of different things with it. You could do what the government says and just follow it. Or you could say, well, Goodyear is good law as far as it goes, but we don't think it goes quite as far as to say you can never have a generic .com trademark. And I think there was some conversation on the bench about, well, could we not adopt that categorical rule, government, but still give you something that gives you most of what you want in terms of protecting consumers from confusion, in terms of allowing competition to flourish in the online marketplace? Is there a way that we can give you kind of half a loaf here? And so I think that seems like the soft landing that is most likely. In my opinion, is that the government may not win this particular case, or they may not win right away, but they might win, on remand, who knows? I thought that there was a really interesting trend at the oral argument also of basically booking.com trying to say, this doesn't matter at all, in the sense of yeah, we want the trademark, but we would never sue anybody to enforce the trademark. That was really their position, was what we really need it for is we're not going to try and stifle any legitimate competition. We only wanted to sue blatant fraudsters, but by the way, we don't think we're going to win those lawsuits either. Was kind of how they had put that.
The blatant fraudsters, they did think they would win the lawsuits against those people. It's just where I thought they said that if they were suing somebody like eBooking and trying to get them off, I thought that they didn't think that they would win that suit. But I thought that they thought that they wanted some of the trademark remedies that are strong against the true fraudsters. I thought fraudsters they weren't saying fraudsters are going to beat us in court. I thought that was right, but maybe I was. Yeah,
so I mean, this is just this is on page 56 of the transcript. Lisa Blatt's answering the question, and she says, we wouldn't object to ebooking.com or anything like that. Now, if there was fraud and somebody ripping off the goodwill based on booking.com, I'm sure they'd want to sue, but it would be very hard to bring that lawsuit. Very hard. Well, and so I think that they are accepting that even in the cases of the fraud, you're going to be looking at a situation where the trademark is not going to add a ton of value to what they can do. Now, whether that's true or not, I would say it's an interesting litigation tactic, right? To stand up and say to the Supreme Court, we are here in the Supreme Court, we really want this trademark. This trademark is not going to help us at all. And, I think the lowering the stakes was part of their effort to address the government's strong monopoly argument, right? That's what they really want to do, is diffuse the bomb that is the government saying they're going to go after all their legitimate competitors and really gum up the marketplace. But in the process of doing it, I think they did get some pushback questions that were like, well, why do you want, what does this matter? And I think so as a result, I think one way that this case could go is I think that there is actually a felt sense among a lot of members of the court that if they could get to a world with less litigation generally, they would want that. And so they would want, both fewer lawsuits to enforce trademarks that they regard as questionable or weak, and also fewer lawsuits of the PTO vis-a-vis its registration decisions. I think if the government is going to win this case, and I'm not by any means sure that it is, it may come from a felt sense that just Booking.com's rule is a recipe for just, reflexive lawsuits whenever trademark registrations are denied, or potentially from businesses that aren't as willing to assuage the court as Booking.com, all the other generic .coms bringing their lawsuits to enforce generic marks against real competitors.
Right. Well, I did think that in the oral argument saying it is one thing to say we'd have a hard time winning that case. It means that there's many trademark doctrines that would cabin in Booking.com's intellectual property rights. But I think they still did assert multiple times in the argument that they would go after people like that. And of course, going after people like that is a serious tool in the sense if you have that weapon in your arsenal. Many of the people who are true fraudsters, you may never get to judgment on, because as soon as you bring actions against them, they might just sort of crawl back into the woodwork and go away. So I think there are reasons why they want this. You're right that they definitely lowered expectations here, and I think that's a fair point on both sides. Both sides were doing that. Both the government and the Lisa Blatt for Booking.com were saying that the stakes here are not so high. The government was saying there's other doctrines, there's other law that that parties can use, like unfair competition law. So when it comes down to it, this is a question that gets into the weeds of what are the remedies of each particular area of law. And Booking.com, even if Booking.com loses this case, they're still going to be a business. Their business is not going to go away. They'll still have lots of avenues of protection. I think everybody acknowledged that. But it did seem like there were points that they did want to say that this would help us and that they should not be at an unfair advantage vis-a-vis their competitors. In fact, I thought one of the worst points for the government was in summing up her argument. Erica Ross for the government said, we've given out a trademark for tickets.com, but they don't actually, they're not actually in the tickets. They give ticket management services. And I must say that is one of the weakest points of the government's case, that they've given out a lot of generic.com trademarks, but said, well, it's not quite in the same field. And some, I think they've got a decent argument, like they've given out law.com, which actually does not provide legal services or laws. It's a legal newspaper basically online. But tickets.com, you got to be, that's ticket management services. That seems like so close to the sort of generic market, in that it just seemed like the very last thing the government would want to pick to sum up their argument, because it seems like it's hard to make that distinction, and that's one of the weakest parts of the government's argument.
Yeah, I was actually interested that they were not pressed that much on this broad point, this inconsistency point that you and I think both in our preview thought would be a major sticking point for the government, that, they have issued so many marks for things that to our eyes look pretty generic. And the distinctions that they use to justify those registrations have tended to be, in my opinion anyway, rather thin. I thought it was interesting that with all 9 justices asking questions, no one really chose to spend the full 3 minutes just digging in on, like, how can you possibly say, that you have a coherent registration policy here when you've got this. And, it was interesting. You would have sort of assumed, I think, based on the way that some past trademark cases have gone, that that would be a major theme.
It might show that they that none of the justices were really attracted to a per se rule, because if you think the per se rule is where the court might go, then all the boundary cases matter a lot. The consistency is a huge issue. If as I think some of the justices thought that they weren't going to go that way, and that it was more likely that they were going to have some middle ground in which maybe the standard for getting one of these marks is high, but still it would all be a matter of proof about what people could do. And I thought that that came out, and Justice Kagan, I think, led off this by saying, are you really asking the government, are you really advocating for a categorical rule? And I think that the government's answer even there was, well, mostly a categorical rule, but there's sometimes when it's not categorical. The government's advocate actually gave an example of tennis.net might be an example where we would grant trademark because the sort of combination of tennis and net is sort of funny, and therefore it might have extra meaning. If anything, it seemed like a bad example to me. It seems like tennis.net then gives you more monopoly power, if that's what the justices are worried about, because what site do you go to if you want your tennis equipment? Well, you go to tennis.net. So I thought that was interesting. Also, Justice Gorsuch was the justice who just said at one point, put Goodyear aside to the government's advocate. In other words, let's assume that you don't win your major argument here. What else would you want the court to say in an opinion? What would help you do your job and give us good trademark policy if we set Goodyear aside? So maybe that's the reason they weren't going into the inconsistency so much, that they really didn't think that the government had such an attractive position if it's framed as a categorical rule.
Yeah. So there are two questions waiting in the chat, and as we approach the end of our half hour together, I wanted to circle back to them. One is actually quite related to what you said. There's a question which is, could you elaborate on what a per se rule entails? And I think this is an interesting question for the argument. So the government's position is, if you have a term that is a generic term, that it means just a term that describes the thing that the business sells, then you cannot trademark your company name if your name is just that generic word plus .com. And it doesn't matter what consumers think, right? It doesn't matter, for example, that consumers think booking.com is a company as opposed to just a generic bookings. That is the per se rule of Goodyear. Now, one point that the respondent, booking.com, pressed in this case is that that's like kind of circular, because how do you tell if a word is just the generic word for the thing? Well, the only way you should tell is by asking consumers if that's how they think of it, because if consumers don't think of it that way, then why would you say so? Now, you could look at a dictionary, of course, or whatever else to come to the other meaning, and that's, I think, what the government would say. But it was a point that the respondent pressed, which was that the government doesn't actually have a good way to define this other than common understanding. And that means that their rule is actually not so different from booking.com's rule, except that it's being used to ignore pertinent evidence, which you wouldn't want to do, generally speaking, in the trademark context. So that was the specific per se rule that was at issue here, was just under what circumstances, if ever, can a generic term be trademarked? The government's per se rule was never. John, did you have any other thoughts about how the rule?
I just want to say one other thing, that the government, another tweak on the government's per se rule. I agree with everything you said, but then it's only targeted towards the business that I think sells that particular thing. And even there's some weird flexibility. So for example, the government has objected to hotels.com in certain service areas, even though hotels.com does not sell hotels. It's not in the business of selling commercial real estate. It's in the business of doing very much what booking.com does, which is selling bookings in hotel rooms. Law.com and tickets.com is another example where the government has issued trademarks, and even hotels.com, even though they objected and won at the Court of Appeals for the Federal Circuit, they've issued hotels.com other trademarks for things that are kind of associated businesses around what hotels.com does. So one is hotels.com for providing an app that allows you to make reservations. So the hotels.com app, if you download it, it has trademark protection within that marketplace of electronic services. And the tickets.com one was the one that the government closed her oral argument with, which again, I thought was a very weak thing. So it's this very targeted rule. And even there, you might say, well, how do consumers know which business it's in? Is law.com about legal information, which is what law.com actually provides, like a legal newspaper, or is it about legal services? It seems to me you'd want to do survey evidence about what people thought. I mean, maybe you could even imagine booking, meaning, I guess government under its position would trademark booking.com if it were for selling books, because it would be kind of a pun then. It's not about booking, like booking a reservation. It would mean books. So they probably would allow that to be trademarked.
Yeah, no, that's interesting. So I think, as we wind up our half hour here, I want to thank everybody for coming out. There's going to be more of these seminars for I think all of the cases that are being argued in these next couple of weeks here on scotusblog.com, which I think we have trademarked. And we'll look forward to seeing you all.
Well, you don't actually sell SCOTUSs or Supreme Courts. You don't actually sell that, right?
Well, not yet.
Not yet, but well, if you do go into that business, you won't get your trademark won't be extended to that field if the government stays.
All right, that's one consideration.
Thank you very much for having me.